Very good evening, friends. Today we will be covering some of the allied laws which are covered in the syllabus. So what I have done is this PPT I have already shared in the group, and in this PPT I have shared the links of my earlier videos also on each of the topics. So what you will be observing from here is that there is a lecture of 1 to 2 hours on each subject which is covered. So I'll be mu- I'll be mu- I'll be muting all. ये क्या होता है? There is lot of echo, so I'll be muting all. Okay. अब देखो भाई, जिसका भी शोर आएगा he'll be removed from the class. ऐसे तो क्या होता है? देखो मुझे तो कोई फर्क पड़ता नहीं है, लेकिन क्या होता है बाकी सबको डिस्टर्बेंस हो रहा है ना इससे. तो चट्टोपाध्याय जी, आई एम मेकिंग यू को-होस्ट, so you can keep on updating people, और जहां से भी शोर आए उनको you can remove them also.
Okay, sir. Okay.
So this is the link. Actually, from this link you will observe that there is a 1 to 1.5 hour video on each of the topics covered. But let us see how much we can cover. Let us start with this Limitation Act. As we know, generally suits have more limitation period than appeals or application. There was a question in the group also that what is the difference between a suit, appeal and application. I have already shared some of the contents on the topic, but suit basically means a plaint which has been filed by the aggrieved party to seek remedy from the court of law. Appeal is basically to counter the decision made by the first authority. And application is a wider term. Application includes suits as well. But in certain situations, no particular format is prescribed for seeking remedy. So application is a wider term than a suit. So generally, this is the suits have more limitation period than appeals or application. This is because in suits, the whole of the process, the whole procedure is starting, whereas in appeals and application, procedure is already in process. So some of the deliberations have already been made on the matter which is under consideration, and naturally, so this appeal, in appeal, what the officer will do, what the adjudicating authority will do, they will go at they will just see the decision made by the earlier authority, and what are the deliberations made, what are the suggestions made, what were the submissions and all those. So generally, suits require longer period than appeals and applications. So this Limitation Act, it is based on the doctrine of laches. So public policy requires that the dispute between the parties should not remain uncertain for a long period of time. Why? This is because the proceedings may become stale. Witnesses may not be interested in giving evidence. Some of the witnesses might have even died. They may have forgotten the whole facts, and chances of fabrication are more. So definitely, within a limited time frame, the decisions should be made. Basically, this Limitation Act is divided into three parts. First is the general bar under Section 3, then exceptions under Section 4 to 11, and then there are certain exclusions on sections 12 to 24. So this is basically divided into three parts. Regarding general bar, we all know limitation period is normally 3 years. It is longer in case of property related matters and shorter in case of tort related matters. This Limitation Act, it favors the plaintiff, applicant or the petitioner by providing the exceptions wherein they are allowed to file the appeal, application or suit even after the expiry of the prescribed period. In exclusion, the time specified in the exclusion sections are added to the PP. Suppose you are a minor. So definitely as a minor, you cannot pursue your remedy. You cannot exercise your right, what is allowed by law. So suppose you are 14 years and you will become major in another 4 years. So to the 3 years, which is the basic period, 4 years will be added. So this is the concept of adding period. And sometimes certain period is excluded also. Suppose some period was lost because you filed your case in a wrong court, and we will read about all these things in detail. So in exclusion, the time specified in the exclusion sections are added to the PP. The exclusions under 12 to 24, they favor the defendant or the respondent. Hence, the Limitation Act, it balances the interest of the plaintiff and the defendant. Thereby, the whole act is based on the balancing of interest. Then there are certain particular terms which we must know, and sometimes questions are being asked on this also. One is the doctrine of lax-forum, law of the forum. Means Limitation Act of that court will apply wherein the suit, appeal or application has been filed. Then another term is lex loci, law of the land. It refers to law of the land. Perimeteria. So perimeteria means something equivalent. Suppose you don't find any particular term in a law, in a particular law, but in other laws the same term has been explained. So definitely they will borrow the meaning from that law. So that is the concept of perimeteria. The parties, they can neither increase nor decrease the limitation period. So this is another important thing, that parties cannot agree to what is uh, stated in the law of limitation. Defendant even cannot waive the defense of limitation by agreement. So the court is also not allowed under section 151 CPC to reduce or increase the limitation period, nor can the court refuse to dismiss the suit, appeal or application if the prescribed period has expired. So this is evident from the use of the word shall under section 3. So no party, no court can increase or decrease the period of limitation other than what is already written in the law. Another important thing to remember here is that the Limitation Act only bars the remedy, but it does not extinguish the cause of action. Suppose you are able to satisfactorily explain the delay, so definitely that period will be added. So hence in this manner, it is procedural in nature as the right stays intact. ये गिरीश खाकर जी आप म्यूट कर लीजिए अपने को. So this Limitation Act, it only bars the remedy, but it does not extinguish the cause of action. Hence, in this manner, it is procedural in nature as the right stays intact. So definitely right is there, just the remedy has been barred, and that right can be reinstated. But sections 25 to 27, they not only bar the remedy, but also extinguishes the right. Suppose more than a reasonable period has already lapsed. So then even the right is extinguished after the expiry of the limitation period, and hence Limitation Act becomes the substantive. Another term which is required is prescribed period. So section 2J, section 2 contains the definitions. I just reproduced the section 2 also in the group. I hope some of you must have already referred to it. So period of limitation means the time period prescribed in the schedule of the act, whereas the prescribed period means the period of limitation computed in accordance with the provisions of the act. So one is prescribed and then period of limitation, which is computed. So something is added to it, something is excluded from it. Then date of reckoning. So date of reckoning means the date from which the counting is done. So Chakravarti ji, please keep on adding people. So date of reckoning means the date from which the counting is done. That is day from which the period of limitation starts. So section 12(1) of the act provides that the day of reckoning shall be excluded. So the particular day. So for example, if you want to file an application for setting aside the ex parte decree, then the period of limitation is 3 years. So the prescribed period will be 3 years plus 1 day if no other exclusions are to be added. So the date of reckoning shall be excluded. So 3 years plus 1. So the most important in this limitation, section 2 contains definitions, section 1 talks of jurisdiction. So section 2 contains definitions. Section 3, this prescribes the normal period. So subject to the provisions of section 4 to 24, every suit, appeal or application filed after the prescribed period shall be dismissed, even if no defense of limitation had been set up. Suppose the party, the defendant, it does not raise the plea of limitation. Even then, it will be dismissed, suit, appeal, or application if it is filed after the prescribed period. Then section 3, subsection 2, subsection A says the suit is said to be instituted when first the suit is presented in proper officer of the court. In the case of a pauper, when the application for leave to sue as a pauper is made. In case of a claim against a company being wound up, when the application is made to the official liquidator. In case of counterclaim or set off, it shall be treated as a separate suit. So suppose there are two suits, one is the original suit and another is a case of counterclaim or set off. Then that is treated as a separate suit and it shall be considered to be instituted. In case of set off, it is said to be instituted on the day when the suit in which set off is claimed is instituted. And in case of counterclaim, it is said to be instituted on the day when the counterclaim is made. In case of application by motion to the High Court, it is said to be instituted on the day on which application is filed in the proper officer of that court. So this is the period how it is to be computed. The court can suo motu also raise the objection of limitation. So suppose the defendant does not raise the plea of limitation, the court can suo motu take cognizance of the period of limitation that this right is barred by limitation. It is mandatory on the court to dismiss as the word shall has been used. So if a suit, appeal or application has been instituted after the prescribed period, then it is mandatory for the court to dismiss. And a suit is said to be instituted when the two copies of the original plaint is presented to the court. So this has been provided under Order 4 and Section 26 of the CPC. So Order 4, Rule 1 states, every suit shall be instituted by presenting a plaint in duplicate to the court. As we know, as per the rules of CPC, suit is supposed to be instituted when a plaint is presented in duplicate to the court or such officer as it appoints in this behalf. Every plaint shall comply with the rules contained in Order 6 and 7 so far as they are applicable. The plaint shall not be deemed to be duly instituted unless it complies with the requirements specified under Sub-Rule 1 and 2. Section 26 states, every suit shall be instituted by the presentation of a plaint or in such manner as may be prescribed. And in every plaint, facts shall be proved by affidavit. So whatever are the facts one wants to prove, they have to be proved by affidavit. The officer may have given the plaint back to the plaintiff for corrections, and he may also have made such corrections in the plaint and then filed it. Still, the date of institution would be the date on which the plaint was presented to the office first. So here there is a difference between the date of initiation as per IBC. In IBC, we know that the date of the initiation date is the date when the petition is presented to the bench duly complete. But here the original date of filing, provided the whatever are the conditions specified in the sub rules are met, so that is said to be the date of institution of complaint. So here there is a fine difference between the IBC provisions regarding initiation date and here the date of presentation of the plaint when a suit or appeal or application is said to be instituted. However, if the court returns the plaint as the property was undervalued and the plaintiff reduces or strikes out the property in order to bring it to the amount specified in the plaint, then the doctrine of relating back will not apply as the subject matter has changed. So, unless the subject matter has changed, the date of institution shall be the date of presentation of the plaint. But if there is a change in the subject matter, then the doctrine of relating back will not apply. This is not so important. Section 4. Section 4 says, if the prescribed period for any suit, appeal or application expires on the day, suppose there is some holiday, court is closed, so suppose it's a Sunday, then it may be filed on the date when the court next reopens. And what is important here is, even if court is closed for some period of the day, then it is said to be closed. The court shall be deemed to be closed if during any time of the normal working hours it remains closed. So I would like to explain it with the help of an example. Suppose on Republic days there is some holiday in courts. So suppose courts will not run after 1 p.m. or 12 o'clock because of some security reasons, because they have to check the premises. So then the court shall be deemed to be closed. In criminal matters, there are duty magistrates even during holidays, but this is not the case in civil cases. So here, this is not an exclusion whereby the days when the court is closed will be added to the PP. Rather, it is an exception and it has to be filed when the court reopens next. And in section 4, the limitation period is not shifted, rather it is an exception to section 3. And as per the explanation, even if the court is closed for a limited period, as I said, suppose even if it is closed for 2 hours, it is deemed to be closed. And this is based on two maxims. First is lex non cogit impossibilitia. Law cannot force you to do something that is impossible. Suppose court is closed, then how you can institute your suit, appeal, or application? And actus curia neminem gravit, act of court shall not prejudice anyone. The applicant, appellant, or plaintiff has the right to file the suit even on the last day of the PP. The court cannot question the person on that. The court cannot question, okay, you had 3 years. Why you came on the last day? You could have come earlier. So the court cannot question the person on that. So even if he is filing on the last day, if he comes to the court and he finds it closed, so then he has got every right to move the application when the court next reopens. If the court is closed on the day when on which the prescribed period ends and the plaintiff files the suit on the day when the court reopens, but suppose he files it in wrong court and therefore his plaintiff is rejected and he files it in the correct court, in such a case, he will not get the benefit of section 14, which provides that a person whose plaintiff is rejected due to lack of jurisdiction, the time required by him to prosecute in good faith will be excluded. So suppose he came on the last day, he could not file. Then he came when the court reopened, but he filed it in wrong court. Then what will happen? So this period, this benefit will not be given to him. There are two main reasons because of which he will not get the benefit of section 14. Why? First is, it is implicit in section 4 that the suit is filed after the expiry of the prescribed period. Therefore, when the plaintiff in the instant case filed the suit in the wrong court, he did so after the prescribed period. But he was allowed to do so by way of exception. So it is implicit in section 14 that in order to get the benefit of section 14, the original suit should have been instituted within the prescribed period, which in instant case it was not. So hence in the instant case, the suit will be barred and the time required for prosecuting in wrong court will not be excluded. Section 5. Section 5 is a very favorite section of all the councils. Section 5 says extension of prescribed period in certain cases. Any appeal or application except the application under Order 21 instituted after the prescribed period may be admitted. So the word here is may be admitted. May means it is the discretion of the court. Even after the prescribed period, in the application, or if the appellant or applicant can prove to the satisfaction of the court that there was sufficient cause for not filing it within the prescribed period. So definitely he has to give that he had cogent reasons for not filing it within the prescribed period. If the applicant or the appellant were misled by the practice, judgment, or the order of High Court for ascertaining or computing the prescribed period, then it is a sufficient cause. But the section 5, it only applies to appeals and applications, but not to suits and execution applications provided under Order 21. It only applies to appeals and applications. The reason behind this is that generally the limitation period of the appeals and application is very less, but that of suits and execution applications is generally longer, that is 3 to 12 years. So this is another important thing. We must remember that section 5, it applies only to appeals and applications and not to suits and execution applications. The marginal note of section 5 states extension of prescribed period, but in actual it is an extension of prescribed period and is rather an exception to section 3. Under section 5, the court has discretion because the word uses may. It has got double discretion. First, it has to see whether there was sufficient cause for not making an application or appeal within the prescribed period. Second is, even if sufficient cause is shown, the court still has the discretion. So it is the discretionary power of the court to admit the appeal or application or not. For example, if suppose wife obtains a decree of divorce in her favor from the district judge, then the prescribed period for filing the appeal by the husband is 90 days. After the expiry of 90 days, wife has the right to get remarried. Now, suppose wife gets remarried and husband comes and files the appeal on 100th day and also seeks condonation of delay, stating that he had met with an accident due to which he could not file the appeal on the prescribed period. The court will still not admit the appeal even though sufficient cause has been shown. So he had genuine reason that he met with an accident and he could not file the appeal. But in the meantime, wife got remarried. So the court will not admit the appeal. So it is the discretion of the court. The burden of proof of showing sufficient cause, it rests on the person. I'll be taking question answer at the end or after the end of each act. Please cover important sections only for exam. Okay, let me complete it. देखिए मुझे तो ऐसा लगता है कि एवरीथिंग इज इंपॉर्टेंट. So there is nothing important or unimportant here. Everything is important. First of all, you should understand कि भाई what is there in the act. और एक्ट को ऐसे तो पढ़ा नहीं सकते ना कि भाई 2 सेक्शन पढ़ा दें, कुछ समझ में ही नहीं आएगा फिर आपको. If the prescribed period, including the date of reckoning, is 31 days, the court cannot seek an explanation from you as to why you did not file the suit till 30th day. I know. But it can seek explanation from you as to why you didn't file the suit on the 31st day and every other day after such prescribed period. So every day of delay, you have to satisfy the court as to what was the reason. The court will be very liberal regarding the explanation and will not be hyper technical. This is a very important judgment of Supreme Court, Collector of Land Acquisition versus Master Katiji. It was a 1987 case, Supreme Court. In this case, Supreme Court, it's a very brief judgment, just runs into 3-4 pages. The court will take a liberal approach while dealing with the applications under Section 5. This is what Supreme Court said in this case. The second point the court pointed out was that the court will make a presumption that generally a person will not deliberately cause the delay because he himself will suffer. Suppose his application is not admitted, then he will definitely suffer. So while he will cause the delay. So there must be some genuine reason for the delay. Third is, even if the court condones the delay, the court still has to decide the case on merits. And therefore, not much harm is done to the other party. Second is, court will not be hyper technical while seeking explanation for delay. The court should understand that applicant may have other important matters also. And the fifth was that the fact was that it was the state that was seeking the condonation. It will not be consideration while deciding the application. Because sometimes either the defendant or the applicant is state. So in that case also, that could not be the only consideration. However, the court will take into consideration the impersonal machinery where no one is responsible and the inherited bureaucratic methodology imbued with file pushing, note making, and passing the buck. So this was a very beautiful judgment. It was a very summarized judgment running into just 3-4 pages, I think. And even we have taken the advantage of this case while filing an application for condonation of delay. Of course, there are other judgments also. There are some very recent judgments. And in judgments pertaining to this IBC, the court has not been so liberal. The burden of proof of showing the sufficient cause rests on the person who wants to file the appeal or the application. So it is definitely the onus lies on the person who wants to file the appeal or the application. If the prescribed period, including the date of reckoning, is 31 days, then the court cannot. So this, I think we've already done. These are some other cases. You can go through this. Then section 6. Section 6 says where a person entitled to institute a suit or file an application for the execution at the time from which the prescribed period is to be reckoned a minor. Suppose he is a minor, idiot or insane, or two disabilities are there. He is minor earlier, then he became an idiot also, or insane. Then he may institute the suit or make the application within the same period that would have otherwise had as per the third schedule after such disability ceases. ठीक है, तो next इसमें कोई issue नहीं है ज्यादा. 6.2. Where such a person on the day when the prescribed period is to be reckoned is suffering from two disabilities. ठीक है, or where before his disability ceases he is affected by another disability, then he may institute the suit within such period as provided in the third schedule after both the disabilities have ceased. 6 subsection 3. So section 6 basically talks of disabilities and the time which is to be added to the initial period of 3 years plus 1 day. Section 6 subsection 3, it says when such person dies, suppose a person dies before the disability ceases, then his legal representative may institute the suit during the same period which he would have been allowed to have after his death. 6.4 says if such legal representative also on the date of the death is suffering from any disability like minor, idiot or insane, then he would also be given the benefit under section 6.1 and 2. 6.5. So this is basically regarding the disabilities. Section 8. Before we discuss section 7, section 8. So section 8 says nothing in section 6 or 7 will apply to suits to enforce right of preemption or shall be deemed to extend the prescribed period for more than 3 years after the cessation of the disability or the death. Okay? Suppose disability was removed, he ceased to be disabled. Earlier he was a minor, then he became a major. Then after major, no more period will be added. So preemption right is provided under section 22. It means that if A and B are neighbors and B is going to sell the land to C, then A can stop the sale to C by filing the suit to enforce right to preemption if he is able to pay the same amount to B. So law considers the right to preemption as weak form of right, and therefore benefit of 6 and 7 does not apply to preemption rights. These are the various examples. A is a minor as B is going to sell his property to C. A and C are neighbors. In this case, A otherwise in the suits will have the right to file within the period under third schedule after it becomes major. Okay? So since this is a right of preemption, he will not be able to avail the benefits of section 6. Okay? So in case of right of preemption, this 6 or 7, whatever is contained in section 6 or 7 will not apply. So general rule is that if the person is suffering from disability on the date when the prescribed period is to be reckoned, then they can file the suit or application for execution during the period that would have been available to them as per third schedule after such disability has ceased. But equity requires that injustice is not caused to the other party. So hence the maximum extension that is allowed is 3 years. Suppose the prescribed period is 12 years, particularly in case of properties, and the person is a minor of 14 years on the date of he becomes a major after 4 years. So till the time that he became a major, the prescribed period is 8 years. So in such a scenario, he will not get any additional time by virtue of section 6 and 8, and the prescribed period will be 8 years. So in case of this preemption right, this facility is not available. Then section 9 is when once the time has begun to run, it will not stop. Section 7, an important section. It says when one of the several persons jointly entitled to file, one is under disability, one is a minor, insane or idiot, and discharge can be given without the curfew. So in this case, it will depend upon the fact whether one person can give discharge or all persons have to join. Suppose discharge can be given without the concurrence of such person, then time would run against all of them. But if discharge cannot be given, then time will not run against any of them until such disability ceases. These are some of the case laws which you can see. Then section 14. Section 14 says for computing the period of limitation for application, the time during which the applicant had prosecuted another civil proceeding with due diligence. Suppose he filed the proceeding in a wrong court, which due to lack of jurisdiction, cause of like nature is unable to cause it. So definitely that period lost will be added. Section 14.3 says, notwithstanding anything contained in Order 23 Rule 2, the provisions of 1 shall apply in relation to fresh suit instituted on permission granted by the court on the ground that the first suit must fail by reason of defect in the jurisdiction of the court or cause of like nature. Then this is regarding agent. These are some of the cases which you can go through. This is the schedule which is given in the Limitation Act. So normally you will see that the normal period is 3 years. But in case of matters related to property, it is sometimes 12 years, 20 years, etc. So you can just go through the aberrations. Like in suits related to immovable property, normal period is 12 years. But ये है कि when the money becomes secured by the mortgage and it is the suit for foreclosure, then it is 30 years. So this way you can study all these schedules. These are some of the questions which you can go through. And I have provided the answers also at the end. Then Prevention of Corruption Act. Prevention of Corruption Act is basically for public servants who have got the patronage of the government. They are getting some remuneration from the government. It does not include private service officials. So basically, these can have these deal with offenses relating to bribing of a public servant. So public servant, who is a public servant? Public servant means any person in the service or pay of the government or remunerated by the government by fees or commission for the performance of any public duty. Then any person in the service or pay of a local authority. Then any person in the service or pay of a corporation established by or under central, provincial or state government or an authority or a body owned or controlled or aided by the government. Then any judge, including any person who is discharging any adjudicatory functions, any person authorized by court of justice, any arbitrator, any person who holds an office, any person who holds an office by virtue of which is authorized or required to perform any public duty. Then any president, secretary, or other office bearer of a registered cooperative society which is engaged in these specified things: agriculture, industry, trade, or banking, receiving or having received any financial aid from the central government. So this is the definition of public servant. Then chairman, member, or employee of any service commission or board, like say Banking Service Recruitment Board or UPSC, etc., Staff Selection Commission. Then VC or member, professor, lecturer, reader, teacher, employee of any university. Then any person who is an office bearer or an employee of an educational, scientific, social, cultural, or other institution, basically receiving any financial assistance from the government. Say aided school is there. So definitely that will be included in the definition of public servant. And undue advantage means any gratification, whatever other than the legal remuneration. Now the important section here is section 7. Section 7 says offenses relating to public servant being bribed. So this Prevention of Corruption Act, it includes various types of offenses. First, it could be the offense relating to public servant being bribed. Then it could be taking undue advantage to influence public servant. It may be done by some other person also. Then offenses relating to bribing of a public servant. Offenses relating to bribing a public servant by a company, commercial organization, and so on. So let us see first section 7. Section 7 says, if any public servant, suppose there is any reader in a university, there is any clerk in a university, and you go to him to obtain mark sheet, he asks you to pay 100 rupees. So that amounts to bribe. So if he obtains or accepts or attempts to obtain from any person an undue advantage with the intention to perform or cause performance of a public duty improperly or dishonestly, or to forbear or cause forbearance to perform such duty either by himself or by another public servant. There is an official in a building department of the government of India, municipal corporation. Then he agrees to not to cause demolition of the property by simply taking some money. So that is an offense which is covered under section 7. Second is obtains or accepts or attempts to obtain an undue advantage from any person as a reward for the improper or dishonest performance of a public duty or for forbearing. So both act, action or forbearance is included. Performs or induces another public servant to perform improperly. He asks his junior to do it, to do something which is not proper, improperly or dishonestly a public duty, or to forbear performance of such public duty. He is the officer in building department. He asks the JE not to do demolition of a particular property and he takes some money in lieu of that. So that is covered under section 7. So the imprisonment is 3 years to 7 years and also a fine. These are the illustrations. 7a. 7 it says taking undue advantage to influence public servant by corrupt or illegal means or by exercise of personal influence. So in this case, it is not the public servant who is committing the offense. It is any person. So whoever accepts or obtains. Suppose a wife of an IAS officer, she takes a diamond necklace from a businessman and she says, I'll influence my husband to do this particular act, which is to the advantage of that businessman. So that is covered under section 7a. So whoever accepts or obtains or attempts to obtain from another person for himself or for any other person any undue advantage as a motive or word. So this is 7a. Second is offense relating to bribing of a public servant. Now, in this case, public servant is not directly involved. तो ये आप ना म्यूट कर दिया करो जो भी आए ना चट्टोपाध्याय जी. और जो म्यूट नहीं हो सकता भैया उसको निकाल दिया जाएगा. अब क्या करें भाई, म्यूट भी नहीं हो रहे और डिस्टर्बेंस भी कर रहे हैं, तो क्या हम क्या करेंगे, फिर निकाल देंगे बाहर. हाँ जी. सो section 8 is offense relating to bribing of a public servant. Suppose there is a criminal. Now this criminal enters into an agreement with another person that okay, I'll intimidate that public servant and ask him to do, you pay me some money. So in this case, the public servant is not directly involved, but the offense relates to bribing of a public servant. So any person who gives or promises to give an undue advantage to another person or persons with intention to induce a public servant to perform improperly a public duty or to reward such public servant, he shall be punishable. Now in this case, who will be punishable? Who gives or promises to give an undue advantage. In this case, the criminal who gave the promise to another person to influence the public servant will be punishable with imprisonment, not the public servant. And it will extend to 7 years. So in this case, you will notice that there is no minimum punishment. In earlier cases, it was 3 to 7 years and also fine. Here it is maximum 7 years or with fine or with both. Next. Provided that the provisions of the section shall not apply where the person is compelled to give such undue advantage. But suppose he was otherwise also duty bound to do it, then the provisions of the section will not apply. Provided further that the person so compelled shall report the matter to the law enforcement authority or investigative agency within a period of 7 days from the date of giving such undue advantage. Suppose a civil servant, pistol was put on his head to sign the paper. Then he obliged, he signed, but he has a duty to report the matter within 7 days to the law enforcement agency or investigation agency that I was compelled to do this. Okay. Provided also that when the offense under the section has been committed by commercial organization, suppose a company, then such commercial organization shall be punishable with fine, because company definitely cannot be put to imprisonment. Section 9. Section 9 talks of offenses related to bribing a public servant by a commercial organization. As we know, in corporate world, it is a practice sometimes to bribe the public servant to get the work done. So suppose it is a company which is involved, then definitely both the person and the company will be under some sort of punishment. But suppose the company proves that it had placed adequate procedures in compliance of such guidelines as may be prescribed to prevent the persons associated with from undertaking such conduct. Because some companies are very particular, they strictly instruct their employees not to give any bribe to any public servant. So in this case, then definition of commercial organization is also given that you can go through. Section 10 talks of person in charge of commercial organization. He will be guilty of the offense. Then section 11, public servant obtaining undue advantage without consideration means either free or at a very low rate, without consideration or for a consideration which he knows to be inadequate. You are a VAT officer, you go to a shop, you ask the shopkeeper to raise you a bill, but the price is 5,000 rupees. You say you raise the bill for 2,000 or 1,000. So that is covered under section 11, because the consideration is either without consideration or for a consideration which he knows to be inadequate. Section 12 is punishment for abatement. Then 13 is criminal misconduct. This all you can go through. Provision for habitual offender. Then it may extend to 5 years to 10 years. Earlier it normally is 3 years to 7 years. Then punishment for attempt is also there. Not less than 2 years, but may extend to 5 years in fine. Investigation and audit. This you can go through. Attachment for forfeiture of property. Code of Civil Procedure. Next is prevention of money laundering. In this money laundering, this is the FAQ. You can go through on your own because all these questions and answers are self-explanatory. Let me give you some of the basic definitions of this money laundering and what is covered in that. Basically, money laundering means that you are putting the tainted money into system. So money laundering is directly or indirectly who attempts to indulge or knowingly assists or knowingly is a party or is actually involved in any process or activity connected with the proceeds of crime. So it should have some connection with the proceeds of crime, including its concealment, possession, acquisition or use, and projecting or claiming it as untainted property shall be guilty of the offense of money laundering. Suppose there is a thief. Now his main aim is to steal money from people, but ostensibly he puts up a shop also. He puts up a shop and he says that I am doing business and I am getting money in cash. And he files return also, everything he does just to hide his crime. So this money is connected with proceeds of crime and he is trying to put it into the system. So he shall be guilty of the offense of money laundering. And even attempt is included in this. Attempt to indulge or knowingly assist. So suppose some person knowingly assists him, he is also a party, or knowingly is a party, or is actually involved in any process, activity connected with the proceeds of crime, including its concealment, possession, acquisition or use, and projecting or claiming it as untainted property. So the proceeds should be as a result of criminal activity and property derived or obtained from proceeds of crime or related to a scheduled offense. This is what is the definition of this money laundering. What is the punishment? This is an important section. So if it has got something to do with NDPS, narcotic drugs and psychotropic substances, then the punishment is 3 years to 10 years. But otherwise, if it is not considered to NDPS, then it is 3 years to 7 years. Now, how this Prevention of Money Laundering Act is implemented? It is implemented through a set of officers. So attachment of property. So first step in this case is the attachment of property, which is involved in money laundering. So here there are certain officers who are authorized to act. So where the director or any other officer not below the rank of deputy director, authorized by the director for the purpose of this section, where he has reason to believe, and such reasons have to be recorded in writing on the basis of material in his possession. So he should have, it should not be merely hearsay. It should be on the basis of material in his possession, that any person is in possession of any proceeds of crime, and such proceeds of crime are likely to be concealed, transferred, or dealt with in any manner which may result in frustrating any proceedings. Then what he will do? He will provisionally attach the property for a period not exceeding 180 days from the date of the order in such manner as may be prescribed. So it is a provisional attachment. So first of all, so there is an apprehension in the mind of the officer who is not below the rank of director or deputy director that this man is connected with some criminal activity and is likely to conceal, transfer, or dispose of the property. Then he may provisionally attach such property. What are the conditions? First of all, he has to report this. Report has to be forwarded to the magistrate, or a complaint has to be filed by a person authorized to investigate before a magistrate, and a similar report or complaint has been made or filed under the corresponding law of any other country. Suppose this offense is committed in some other country. Provided further that any property of any person may be attached. Now, person A is committing the crime, but property is with B. So then property of any person may be attached if the director or deputy director feels that if such property involved in money laundering is not attached immediately, the non-attachment is likely to frustrate. So the property of the person connected with the proceeds of crime or some other person also may be attached. Provided also that for the purpose of computing the period of 180 days, the period during which the proceedings were stayed by the High Court, suppose that person obtains a stay from the High Court, then that period will be excluded from the period of 180 days. And a further period not exceeding 30 days from the date of order of vacation of such stay order shall be counted. So the stay plus 130 days from the date of order of vacation of stay. Now, after provisional attachment, what the director or deputy director will do? Immediately after attachment, what he will do? He will forward a copy along with the material, whatever is attached, to the adjudicating authority in a sealed envelope. Okay? And every such order will cease to have effect. That means the uh, uh, prescribed period of 180 days. When no, now this definitely some order will be made. Either he will be acquitted or he will be punished. So that order will cease to have effect on the prescribed period. But nothing in this section shall prevent the person interested in the enjoyment of the immovable property attached under subsection 1 from such enjoyment. Suppose there is an immovable property. Suppose there is a smuggler and he is having a residential house. Then that house may be attached, but he may continue to live in that, or his family may continue to live in that. For the purpose of this subsection, person interested in relation to any immovable property includes all persons claiming or entitled to claim any interest in the property. And the director or any other officer who provisionally attaches any property under subsection 1 shall within a period of 30 days from such attachment file a complaint stating the facts of such attachment before the adjudicating authority. So provisional attachment is for 180 days, and within a period of 30 days, he will file a complaint. Now, adjudicating authority. what is the composition, etc. All are given here. Okay, who can be appointed as chairperson, etc., etc. What is the jurisdiction transfer? All these things you can read. So then the serving of notice by the adjudicating officer. Now suppose the complaint is received. Now the adjudicating authority has reason to believe that any person has committed any offense. Then he will serve a notice to him, not less than 30 days. So he will be called to explain his sources of income, earning or assets by which he has got this property. Okay? Then this property may be seized or frozen also. Where a notice under this subsection specifies any property as being held by a person on behalf of any other person, suppose criminal is A, but this property is held by B, then that person will also be served notice. Where such property is held jointly by more than one person, such notice shall be served to all the persons holding such property. Order passed. Now, definitely the adjudicating authority, either it will be satisfied or it will be dissatisfied. So, depending upon that, that will pass the order. Okay? And if the property is claimed by a person other than the person to whom the notice had been issued, such person shall also be given an opportunity. Definitely. Suppose A is a criminal and notice has been issued to B also on the apprehension that he is enjoying that property. So then definitely he will also be required to explain. But he will also be given an opportunity of being heard that the property is not involved in money laundering. Then confirmation of execution of past order. Now the adjudicating authority will either confirm or release the property. Definitely. Order of release, etc. This all you can go through. This is all self-explanatory. Punishment for false information. So this was a brief about this prevention of money laundering. Now RDDB versus SURFACE. See. Hmm. Definitely, this recovery of debts and dues from banks and financial institutions and SURFACE, they both these statutes will throw an insight on the recovery of money due from defaulters to the banks and financial institutions. Private parties here are not covered. But what is the scope? What is the difference between these two? These two acts we will study side by side, RDDB and SURFACE. So this recovery of debts due from banks and financial institutions, basically its role is to establish tribunals for expeditious adjudication and recovery of debts due to banks and financial institutions. As we know, prior to this act came into force in 1993. Prior to this, the recovery mechanism was being run through the civil courts. So definitely there was a lot of delay. So that is why it was thought to establish tribunals so that the matters relating to recovery of debts due to banks and financial institutions are expeditiously adjudicated. Now, what is the difference between RDDB and SURFACE? SURFACE is basically for secured assets, whereas this RDDB is for secured as well as unsecured debts due to banks and financial institutions. It is for all types of creditors, whether or not they are secured. In SURFACE, only secured creditors are covered. Intervention of the court is to the minimum. There is expeditious adjudicating at the hands of tribunals. So tribunals are established and the regular courts, the civil courts, they do not have any jurisdiction to entertain these finance related matters, loan related matters related to banks and financial institutions. And the Surface Act, it bypasses intervention of the courts for expeditious recovery of debts of banks and financial institutions, which is public money of which they are custodian. Now this RDB, it is an adjudicating act and Surface is executory in nature. So whatever are the actions to be taken under Surface, they also have to be taken in DRT or DRAT. Then legality of the action taken by the secured creditor under section 13(4), it can be challenged by filing appeal under section 17 of the Surface Act. Whereas in Surface there is no adjudication process, at least till actions under section 13(4) is taken. And that also has to be moved to the, if any party feels aggrieved by the action taken under section 13(4), then it has to move to the DRT. Now there is a question. So whether during pendency of the suit, as we know, both these acts, RDB Act and this Surface Act, both relate to recovery uh, against loans which have been given by banks and financial institutions. RDB, it covers both secured as well as unsecured loans. Surface covers only secured loans. Now the question is whether during pendency of the suit, the defendant bank can resort to section 13 subsection 4. Section 13 subsection 4 of Surface, as we will read later, it relates to repossession of the property which was given as security against the loan after giving notice under section 13 subsection 2 of Surface Act. So answer is when alternative method has been prescribed to recover the amount which the petitioner is liable to pay, and the bank in order to enforce payment has taken recourse to the act which has the overriding effect over other laws, no fault can be found with the defendant bank in proceeding under the act. So even if there is any suit is pending, so bank can resort to action under section 30 subsection 4 regarding repossession of the property. So this is the case law, Debt Recovery Tribunal, Ranchi, Sushil Kumar Agarwal versus Allahabad Bank. As I already told you regarding recovery of debts due to banks and financial institutions. So one of the problems of banks in India was the large amount of bad debts. Recovery was very slow. Earlier people were going to courts only and it was time consuming also. As is recovery of debts due to banks and financial institutions, RDDB-FI Act was passed. The act came into effect on 24th of June 1993. Applicability of debt, it is a recovery act basically. So it covers banking companies, SBI, subsidiaries of SBI, regional rural banks, multi-state cooperative banks. They can make application to DRT. So section 2D of this RDDB Act, it says that financial institutions can also make application to DRT for recovery of debt. And basically public financial institutions are covered, private institutions are not covered. So public financial institutions within the meaning of section 4A of the Companies Act, asset reconstruction companies registered under the Surface Act, then debenture trustees registered with SEBI, and other institutions as may be notified by the central government, they can resort to action under RDB. Now, what is the meaning of public financial institution? LIC is covered, then infrastructure development finance is covered, then specified company referred to in UTI Act is covered, institutions notified by central government and such other institutions. So this is the definition of public financial institution. IDBI, ICCICI, IFCI, LIC, UTI, GICI, SCICI, SIDBI, state financial corporations, NABARD, NCDC, etc. But this RDB Act, this DRT Act, it does not extend to cooperative banks. The act applies to banking company. A cooperative bank is not a company. So dispute between cooperative society and its members, they are to be decided by registrar of societies. As the DRT Act does not apply to cooperative societies. Now what is the monetary limit? Now it is 20 lakhs. Earlier it was 10 lakhs. RDB Act and Surface Act, they are complementary to each other. Actions under both act are possible. Okay? So I have given some reference of case laws also, which you can refer. Then Limitation Act. Whether Limitation Act is applicable? Yes. Limitation is applicable for making application under DRT. Now, priority of this secured creditors. So, secured creditors, they will have priority as specified in IBC after relevant provisions of that act is notified and made effective. Then section 31B of that gives property to realize secured debts due and payable to them by sale of assets. Meaning of order, meaning of debt. What is the meaning of debt under RDB Act? So debt means any liability. The definition of debt is given in IBC also. So debt here means any liability inclusive of interest which is claimed as due from any person by a bank or a financial institution or by a consortium of banks or financial institutions during the course of any business activity undertaken by the bank or the financial institution. Under debt, even private lenders are covered in case of IBC, but here they are not. Whether secured or unsecured or assigned or whether payable under a decree or order of any civil court or arbitration award, etc. Then debt security means debt securities listed in accordance with regulations made by SEBI. Security interest definition is in IBC also. So you can make a comparison between what is there and what is here. Security interest means mortgage, charge, hypothecation, assignment, etc. Financial lease, operating lease, everything. Then secured creditor, property, all these definitions are given. So debt may be any liability inclusive of interest due to bank or financial institution. So it may be secured or unsecured or even assigned debt. So this act is mainly a procedural act. DRT Act does not make any substantive provision in respect of debt or its recovery. It is primarily a procedural act. Now, what is the procedure? It's a procedural act, but what is the procedure? So first of all, bank or the financial institution, they have to file an application. Now the question here could be whether the other party can file the application. No, it is only the prerogative of the bank or financial institution who has given the loan. Only it can file application in prescribed form along with necessary appeal fees for recovery of any debt from any person. Application should be accompanied with true copies of all documents relied upon support of the claim. Then application shall be supported by affidavit, sworn in verifying all the facts and proceedings. Then part of the fees will be refunded if claim is settled before final order. And document means any statement of account or any entry in banker's book, duly certified under Banker's Book Evidence Act. We just 2-3 days back had a special session on Indian Evidence Act also. That recording is also available on our YouTube channel, so you can refer to that also. And application should be accompanied by details as specified in section 19(3)(a). Then application to DRT under IBC. In case of application to DRT, to exercise powers of adjudicating authority under IBC, it shall be dealt with in manner prescribed under that code, section 19(a) of RDDBA FIA. Jurisdiction, where is the jurisdiction? So jurisdiction of DRT is where branch office or office of the bank or financial institution which is maintaining account of the debt claim is outstanding, or defendant or each of the defendant is actually residing, the person who took the loan, or carrying on business or personally working, or any defendant or each of the defendant is actually residing or carrying on business, and cause of action in whole or in part arises. So these are the places where the jurisdiction of DRTs, and DRTs are there in almost every state. Then withdrawal of application. Suppose as we saw earlier, even if fees is paid and the application is later withdrawn, then fees is refundable. So if bank or financial institution intend to take action under SARFAESI Act, so bank or financial institution can withdraw application, and if they intend to take action under SARFAESI Act. If such application for withdrawal is made, it should be decided within 30 days. Then if permission for withdrawal is made, written order giving reasons should be passed by DRT. In that case, DRT may allow withdrawal of application. Then another bank or financial institution, something similar to IBC. So suppose one bank has filed the application, then another bank or financial institution can also join. If one bank or financial institution has made application to DRT, Then another bank or financial institution can also apply if they have claim against the same person. Such application can be made anytime before passing a final order by DRT. Then summons to defendant. Suppose the application is filed by bank or financial institution, then summons will be issued to the defendant. So on receipt of application from bank or financial institution, summons shall be issued to defendant to show cause within 30 days and direct defendant to disclose properties and assets and restrain defendant from dealing with assets pending hearing. So these are some of the provisions. And after receipt of summons, the defendant cannot transfer something similar to moratorium in IBC. So after receipt of summons, defendant cannot transfer, sale or lease property except in ordinary course of business. And defendant shall be liable to account for sale proceeds of secured assets in ordinary course of business and deposit sale proceeds in the account of bank or financial institution. Now, when this defendant gets the notice, he has to reply within 30 days. The defendant should reply within 30 days and he can claim set off also. And period of filing reply can be extended by DRT by another 30 days. And reply with claim of set off and counterclaim shall be supported by affidavit. And return statement is as if it is a cross suit so that DRT can pass final order in respect of original claim and of set off. And if defendant admits some amount, suppose he says the bank has raised a claim for 20 lakhs, but of course 10 lakhs is due, then DRT can order defendant to pay the amount within 30 days, whatever amount is admitted by the party. Then civil arrest, suppose he is given a notice, he is given 30 days to apply, another 13 days, but he does not reply. So the provision of civil arrest is also there. If no reply is given by the defendant, DRT can direct that the person shall be detained in civil jail for a term not exceeding 3 months after giving opportunity of personal hearing. Then defendant can claim set off and counterclaim, and DRT can consider it. A reply by applicant to counterclaim. Applicant can submit reply to counterclaim. Applicant here means the bank or the financial institution. Suppose some counterclaim is there, then the applicant can submit reply to counterclaim within the prescribed period. And reply shall be supported by affidavit. Then interim order by DRT to provide a security. Now, if defendant is likely to obstruct or delay or frustrate execution of order, so then DRT can direct defendant to furnish security after giving show cause, notice and opportunity of hearing. DRT can order attachment of property after giving him hearing. DRT can order attachment of property after giving him hearing. DRT can order civil imprisonment if orders are disobeyed. So DRT can order civil imprisonment up to 3 months. And DRT can appoint receiver also. Suppose some property is there and it is apprehended that the defendant is likely to dispose of the property, then DRT can appoint receiver to receive that property of defendant and take it in possession till the disposal of the case. Distribution of sale proceeds in case of winding up of a company. So in case there is a winding up of the company, then DRT can direct that sale proceeds of secured assets be distributed in the manner prescribed in section 326 of the Companies Act. Section 326 of the Companies Act is slightly different from the waterfall mechanism, which is given in section 53 of the IBC. Then final order within 30 days from conclusion of hearing. DRT should pass final order within 30 days from conclusion of hearing, deciding claims, counterclaims, and set off. The order should include payment of interest. Then DRT can make orders and give directions to prevent abuse of process or to secure ends of justice. Effort should be made to complete the proceeding in 2 hearings and dispose of within 180 days. Then distribution of assets. The order should direct the recovery officer to distribute sale proceeds in following order. First of all, cost incurred for preservation and protection, say insurance, etc., cost of valuation, then public notice and auction and other expenses, then debts recovered to banks and financial institutions. So this is the order of distribution of assets as per this RDB Act. And after commencement of IBC, the distribution of assets shall be as specified in that code. Then copy of final order and recovery certificate shall be sent to applicant and defendant. Certificate of recovery. DRT shall issue certificate of recovery to recovery officer along with final order, and it shall be deemed to be decree or order of the court. And in pursuance of that certificate of recovery, recovery officer will effect recovery. And that certificate can be sent to more than one DRT if property is in different jurisdiction, like execution of civil decree. Then proceedings against guarantor. So there is a provision for proceeding against the guarantor also. So liability of guarantor being coextensive with that of the borrower. So DRT can proceed against the guarantor also. And creditor is not bound to exhaust his remedy against the principal debtor before showing the surety. Because if he sees that principal debtor doesn't have any property, then he will directly proceed against the guarantor. You know, while we waste his time. Then procedure to be followed. DRT rules are there. They have been notified for the procedural aspect. And plural remedy is permitted. Sorry. Rule 10 of DRT is provided that plural remedies will not be permitted in one single application. But this rule was omitted with effect from 21st January 2003. Thus, now an application can seek relief or reliefs based on more than single cause of action in one single application. So you can go through all these things. I think this much is sufficient for this. Then arbitration and conciliation. And before we move to this Arbitration and Conciliation Act, I think we should see the Surface Act along with this RDB because that is more important. For this Arbitration and Conciliation Act, we can invite some advocate for a detailed derivation. Otherwise, one YouTube recording is already available and link is already given in my this PPT on slide 2. Surface. Now the surface. First of all, there is a borrower. As we know, in case of bank, somebody who availed the loan facility is the borrower, is called the borrower or obliger. Second is the lender who gave the loan. This is the bank or financial institution. Now, this borrower took financial assistance and then the borrower gave some assets as security. But the borrower failed to pay. Now, once this borrower failed to pay, the banker is not equipped to handle the repossessed assets. So, a third party, these special purpose vehicles, these come into play. These are asset reconstruction companies, which are basically equipped by professionals which can handle these repossessed properties. They can manage those properties. They can run them as business concern, as a going concern, or they can auction those properties and give the money to the banker. But these special purpose vehicles or the asset reconstruction companies, which are basically regulated by RBI, what they do, they issue the security receipts to qualified buyers. Earlier, the term was qualified institutional buyers, but now the term is qualified buyers. And these buyers, qualified buyers, they are basically financial institutions or asset management companies or mutual funds. We will read about them in detail. They are given some assured return in the form of security receipts and they subscribe to the securities. The money which is given by the qualified buyers or investors, that money goes to the asset reconstruction companies. Asset reconstruction companies, after deducting their commission, they give the money to the bank and circle of money is complete this way. So Surface Act, what it does? It basically deals with three things. Securitization. First is securitization and reconstruction of financial assets. Securitization is done by asset reconstruction companies. Securitization means issuing the security receipts to qualified buyers who are giving the money ultimately. And the money which ARC is getting from them, it is passing to the banks for the assets they have purchased from the bank. This is the process of securitization. Asset reconstruction companies, what it means? Asset reconstruction is done by the asset reconstruction companies. They either run the company as a going concern or they auction it or they somehow deal with that property. So securitization and reconstruction of financial assets because it deals only with financial assets, only with the financial assistance which was given by the banks or financial institutions and enforcement of security interest. This enforcement of security interest is done by the banks or financial institutions. Whenever the borrower makes a default, first of all, a notice is issued under section 13, subsection 2 to the borrower to return the money within a period of 60 days after declaring the asset as NPA. So declaring the asset is a sine qua non. So it is an essential requirement that before enforcement of security set, you declare it as an NPA. First, you declare it as NPA, and then you issued notice to asking him to return the money within 60 days. If he doesn't return, then no stay, no injunction. You just take help of police and you repossess the property. But after you repossess the property, what you will do? The banks normally hand it over to asset reconstruction companies, which are specialized agencies handling with such property. And where from this asset reconstruction company get the money? They issue security receipts to qualified buyers. So this is the entire process. So it deals with registration and regulation of asset companies by RBI regarding their management, regarding net worth, etc., etc. Then facilitating securitization of financial assets of banks or financial institutions, facilitating the transferability. So these are some of the functions. So the Surface Act is divided into 6 chapters having 42 sections. First is formation of securitization or reconstruction companies, ARCs. Then recovery is without interference of the court, no injunction, no stay. Then framework for revival or reconstruction of the borrower's business. Then there is a concept of central registry also, like MCA. So similar in this concept here, SARSAI. So any asset, any security, it has to be first registered with the central registry on payment of certain fees. Whenever any charge is satisfied, that also has to be entered. Suppose there is part payment, that also has to be entered. Suppose there is some decree, that also has to be entered. Then there is the concept of qualified buyers who are issued scripts by asset reconstruction companies, and security receipts. Security receipts are issued to qualified buyers. So these are some of the terms. Conditions. So first of all, they have to only secured creditors can take recourse under Surface. An unsecured creditor does not have recourse to this act. So first of all, as I already told you, they have to classify the asset as NPA. And for non-payment of debentures or bonds, a notice of 90 days is to be given. Otherwise, it is a notice of 60 days. Then debt. What is the meaning of debt? It is given. Financial asset means debt or receivables and includes. So debt and asset which is not a financial asset cannot be securitized, acquired or transferred under this act. Only financial assets. Because the term is Surface, securitization and asset reconstruction of financial assets and enforcement of security assets. So only financial assets are covered. And this is the definition of financial asset. Qualified buyers. So qualified buyers, they are financial institutions, insurance companies, banks, SFCs, State Industrial Development Corporation, trustee or asset reconstruction company, which has been granted a certificate of registration by RBI. Suppose these qualified buyers, they are issued scripts, and then RBI, this ARC does not fulfill the promises which it made to qualified buyers regarding assured return also. So in the event of non-realization of financial assets, qualified buyers holding not less than 75% security receipts shall be entitled to call a meeting, something similar to COC, of all the qualified buyers, and every resolution passed in such meeting shall be binding on the company. And ARC cannot raise funds from investors which is not a qualified buyer. So it can raise funds only from qualified buyers. So how these ARCs are regulated? This is given here. So there are certain conditions that they should not have net owned funds not less than 100 crores. So definitely, because RBI is regulating, so there is a power of RBI to inspect books and records of ARC. And what are the conditions? The certificate for commencement will be given only if the ARC has not incurred loss in any of the three preceding financial years. However, after registration, it may incur a loss. And then the ARC, it has made adequate arrangement for realization of financial assets. Directors, they've got professional experience. So these are the conditions for RBI. This ARC. There is the concept of sponsor also. That sponsor means a person who is holding more than 10% of the capital of the ARC. So if all these conditions are met, certificate is granted to ARC. And if there is any change, material change, so RBI has to be informed. So cancellation is also there. If it ceases to carry on in the business, etc., etc. Appeal is there. Appeal can be made to Secretary Ministry of Finance within 30 days. Then acquisition of rights or interests in financial assets. How the bank will acquire the financial assets. So notwithstanding anything contained in any agreement, any ARC may acquire financial assets of any. As we know, the bankers are not equipped to handle the assets. So ARCs, they get the assets from the financial assets of the bank or financial institution. And what they will give to the bank in return? They will issue either a debenture or bond or any other security on mutually agreed terms. Or they will agree to transfer such assets to such company, that means to ARC, on such terms and conditions as may be agreed upon by them. And any document, it is exempt from the provisions of Indian Stamp Act. No registration is required. Now transfer of pending applications, clubbing is allowed. Notice to obliger and discharge of obligations. So bank, what it will do? The bank or the financial institution, it may give a notice of acquisition of financial assets by any ARC to the concerned obliger and any of the concerned person and to the concerned registering authority. And obliger will make payment to the concerned ARC. Exemption for registration of security receipts, measures for asset reconstruction. Now, what ARC will do with these assets? So, ARC may, it may properly manage the business of the borrower by change or takeover, sale or lease, rescheduling of payment, something similar to resolution applicant. So, in IBC, there is a concept of resolution applicant. Here, there is a concept of asset reconstruction companies. Powers of Reserve Bank. RBI is mother-in-law of ARC. So definitely they may instruct the ARC to do certain things and not to do certain things. Power of Reserve Bank to call for statements and information. So naturally, RBI may call for any information or statement from the bank. Then power of Reserve Bank to carry out audit and inspection. So this was regarding ARCs. Next step is enforcement of security interest, enforcement of securitization. How banks will enforce the security interest? They will declare the account as NPA and they will ask the creditor to pay within 60 days. In case of debentures, 90 days. The borrower may raise an objection within 15 days and definitely the bank will communicate within 15 days. But there is no right to borrower to prefer an application. Borrower at this stage cannot make an application to DRT. And if the borrower fails to discharge his liability, then secured creditor may take recourse to one or more of the following actions. Basically, it is the repossession of the asset or taking over of the management. Then they may appoint any person to manage. Modes of enforcement. They can take possession, they can take over the management, they can appoint any person as manager, and they can issue demand notice to the person who has acquired the secured assets from the borrower. Okay. Recovery of expenses from the borrower, payment of dues, etc. In case of of joint financing, how they will manage. So 60% or more of the banks or financial institutions, they should agree for action. Suppose there is financing by 4 banks. So 60% of the debt naturally. So 60% or more, they should agree for action. And in case of liquidation, distribution as per section 326 of the Companies Act. Then no transfer of secured assets by borrower. So consent of secured creditor is necessary for transfer in case of receipt of notice. So once a notice has been received, once the account has been declared as NPA, notice under section 13(2) has been given, then the borrower, after receipt of notice, naturally it cannot transfer or lease other than in ordinary course of business. For taking possession, आंटी पुलिस बुला लेगी तो चीफ मेट्रोपॉलिटन मजिस्ट्रेट और डिस्ट्रिक्ट मजिस्ट्रेट they will assist the secured creditor, read your bank or financial institution in taking possession of secured assets. Then manner and effect of takeover of management by ARC or bank by appointing director or an administrator. So the ARC, it may appoint, it may take over the management. It can even participate in equity of that company. So what will do when the management of a business of borrower is taken? So the secured creditor may by publishing a notice in a newspaper. So there is a public announcement also, okay, that this business has been taken over by us. In case in which the borrower is a company to be the directors of that borrower in accordance with the provisions of that, and in other case to be the administrator of the business. So in this case, ARC will say through public notice that okay, now we have become the director. And in case it is the borrower is other than a company, suppose a partnership firm or a proprietor, then it will say that ARC is henceforth the administrator of the business of the borrower, to make people aware about dealing with that company or other than company. On publication notice, directors are deemed to have vacated notice when any contract of management shall be deemed to be terminated. Okay? Then exercise of the powers of the person so appointed. So there is a deeming fiction that they are deemed to be directors. Shareholders, the power of the shareholders is reduced and they cannot nominate or appoint any person to be a director. And no resolution will have any effect unless it is approved by the secured creditor. Because the definition here used is secured creditor. So secured creditor includes not only the banks and the financial institution, but the ARC as well. Then obligation of secured creditor. Suppose the borrower makes the payment after taking possession by the bank or financial institution or the ARC. Then his director will be allowed. But suppose they have agreed to take the shares, then they will not reduce. They will not be liable to restore the management of the business. No compensation to directors for loss of office. Then application against measure. Suppose the borrower feels aggrieved, then he can make an application to DRT within 45 days of the date of such order. Measures taken shall be in compliance. So DRT to ensure that of course there is no injustice to any of the parties. Time limit. So as soon as possible, normally within 60 days, but total period will not exceed 4 months. Suppose even 4 months DRT is not able to give the judgment, then the parties can approach the DRAT. And if there is a wrong possession, then naturally the borrower has the right to compensation. This is the concept of central registry. It is something similar to National E-Governance Services Limited, which is the only information utility in IBC, or something similar to MCA, in which charges and satisfaction of charges are registered. So on payment of certain fees, on creation of security interest, on satisfaction of security interest, on obtaining any decree, on obtaining any payment or court order, everything has to be registered in this central registry. So this is all self-explanatory. You can read it to it. and there is some fees also. Attachment order also, particulars have to be registered. These are some of the offenses and penalties. Suppose you don't get yourself registered. So these are the penalties. Offenses by company. These are some of the rules which you can go through. Then MSME. In MSME, there is only one important slide which I would like to show, and then we'll conclude the meeting here. So this is the limit. Classification between manufacturing and services has been abolished now. Investment does not exceed 1 crore, turnover does not exceed 5 crores. In case of small company, investment does not exceed 10 crore, turnover does not exceed 50 crores. Medium, investment does not exceed 50 crores, turnover does not exceed 250 crores. Since this is a beneficial legislation, so the shift will be from micro to small, and small to medium, and from medium to out. And there could be a downward revision or upward revision also. This status of micro, small, and medium, because micro is enjoying some special privileges. Privileges to small are lesser than what are available to micro, and privileges to medium are less than what are available to micro and small. And suppose there is an upward division, so the prevailing status will prevail till the expiry of 1 year from the close of the financial year of registration. And it will be considered, the status will be considered financial year wise. And in case of reverse graduation means from small to micro or from medium to small, the enterprise will continue its present category till the closure of the financial year. And how this limit is to be calculated? Composite criteria is there. And suppose GST number is there, so all the units with one GST number and one PAN, they will be treated as one enterprise. Calculation will be linked to income tax return, and purchase value, excluding the GST, is the amount which is to be considered for plant and machinery. Certain this cost of pollution control equipment, R&D, industrial safety devices are excluded. Then exports are also excluded from turnover, and WDV has to be taken. Exports shall be excluded. And information will be GST number wise or PAN number wise. So I think we should stop here, and then we can move on to the other acts tomorrow. So this was RERA. So RERA will do tomorrow. I think you enjoyed this session. This PPT has already been shared by me in the group, and even earlier video lectures are there. And I've given links to all the allied laws of my earlier YouTube videos also in this PPT. So you can go through them at your own convenience. And I think I have shared some questions also. Let me show you. In the end, I have some questions also. So this you can go through these questions also. These are available at the end of the PPT. Even you might have already seen them. So this is a quiz on various acts. Even IBC is covered here. So a lot of acts are covered. Contract act is also there. So you can go through these questions. कौन बनेगा IP? So I hope you enjoyed this session. Thank you very much.
Thank you, sir. Thank you.